My supreme namaskarams to Honorable Padmanabh Garu and his loved daughter Shailaja Garu and all the other students and aspirants of various competitive and big posts. I am comfortable both in English and Hindi and Telugu, but I continue today in Hindi, in English. Wherever you require to have any explanation, either in any language which I referred, you can very well ask me. I was asked to speak to you about Indian judicial system. Indian judicial system actually based on common law system. Why we say what is common law? Common law means a president based judiciary. Like there is a highest court and it gives decisions, and the same have to be followed by all the subordinate or other competent courts working within the judiciary. That is common law system based on recorded judicial precedents which we have inherited from the British colonial legacy. At present in India, the court system is comprising at the highest level the Supreme Court of India, and thereafter the High Courts, and then below to Supreme Court and High Court subordinate courts at district, municipal and village levels. Before I venture to speak to you about the Indian judiciary and the Indian judicial system and how they work, we need to have knowledge of why and how we had a fight and thereafter got independence in the year 1947, August 15th, during midnight, which you know well. Our country was ruled by United Kingdom, that is British government. So we had prayed to British entering into our India, both jurisdiction wise and also in all other aspects, a bigger country, which includes Bangladesh, Pakistan, Afghanistan, and some other countries. Various countries are part of India. Each part or some parts are ruled by kings, zamindars, and at some places religion ruled. Like that, the system was not fully organized and codified. Within the country also, here and there, different laws used to be there. Finally, we fought for freedom and won, and finally we got independence. After that, we have got drafted in the Constitutional Assembly, the Constitution of India. The Constitution of India, after it is promulgated and came into force, we have adopted Indian judicial system to maintain the law and order and implement one law in all the entire India except in Jammu and Kashmir, where we had another constitution, though it is part of our country. I don't go or dwell into various other aspects, but we have adopted Constitution of India with a preamble in which we have enshrined some big objects to achieve by our Indian judicial system or Indian government and whatever it is. Just I refer to the preamble in order to understand about the goals of us. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, democratic, secular republic. These are all the goals. How we achieve? We want to achieve these goals through social revolution. What do you mean by social revolution? What is the method? What are the systems which we adopted? We want to achieve these goals by adopting democracy. You know very well, in democracy in India, election system is that whoever gets majority of the votes polled, they are declared as elected and they will become parliamentarians or MLAs, MLCs, or any other elections like municipality and other things. So after they came into power, after they come into power, they make laws. How to implement these laws? Who are the persons who are deciding what is the law and whether that law is correct or not, and whether that law is within the purview of the constitution or it's acting against the wishes or a constitution, abridging the rights and all that. We have fundamental rights right from Article 5 to 52 or so, and the directive principles of state policy. All this you may be knowing, or in some other class we will definitely discuss at length about various organs that are made or part of our constitution and why they are made and what we want to do it. So democracy is the one of the organ through which we want to achieve our goals. In the democratic setup, which is part of social revolution, law is very important. So unless and until a settled law is there, we can't claim that we are part of democracy and rightly we are proceeding to achieve our goals, rather the goals enshrined in the Constitution of India. So I don't go into the what is government, how it is made and all that today. We will deal with only Indian judicial system because only 45 minutes are there for us today to understand that under various topics. What is the hierarchy of courts? What are civil courts? What are criminal courts? Judicial authority of the Supreme Court and Article 141, Article 144, binding value of precedents, public interest litigation. These are the various topics which we need to understand in order to understand the Indian judicial legal system. So I already told you that the court system, that is judicial system of India, comprises the Supreme Court of India, the high courts and subordinate courts at district, municipal and village levels. When you talk about hierarchy of courts, we need to understand which is the highest court in India. The Indian judiciary is divided into several levels. For what? In order to decentralize and address matters at the grassroots levels. So let us understand what is the basic structure of the Indian judicial system. I am not talking about basic structure of the constitution. I am now referring about the hierarchy of courts, which is part of Indian judiciary, and what is the basic structure of Indian judiciary. we must understand first about the Supreme Court. The Supreme Court is the apex court of the country, and it was constituted on 28th January 1950. 28th January 1950. It is the highest court of appeals and enjoys both original suits and appeals of High Court judgments. The Supreme Court at present is comprised of the Chief Justice and 32 or 36 other judges. Article 124 to 147 of the Constitution of India laid down the authority of the Supreme Court. These articles deal with about how many judges of Supreme Court shall be there and who is the chief of Supreme Court, how he has to be selected or appointed, what is the role of the government and powers of President of India and all that. You have to read articles 124 to 127 of the Constitution of India in order to understand the authority and supremacy of the Supreme Court. Generally, original suits or original cases or criminal cases means the cases in which a particular court has got jurisdiction to try and decide directly by itself by taking the cases on file. This is called original jurisdiction. What is appellate jurisdiction? Appellate jurisdiction means that case is already decided by the one of the courts subordinate to Supreme Court, and then a right of appeal is provided against the judgment of that court. Then from that judgment of that court, it will go to the higher court and finally to Supreme Court. So the Supreme Court is having not only the extraordinary powers being the highest court, both of appeals and also the original suits, in order to have the power to decide the appeals and original suits and also appeals of the High Court judgments. So with this, I say and refer only Article 141 of the Constitution of India, which says the decision and judgment of the Supreme Court is binding on all the courts in India and other authorities also, not only on the courts subordinate to Supreme Court, all other authorities working in India under the government of India or state legislature or state or central governments. So all authorities also, they come into the within the jurisdiction of Supreme Court, and Supreme Court is having all powers to make decisions in respect of any disputes that has arisen within the territory of India or outside the territory of India, but concerned to the law of our country. So Supreme Court is having the original and appellate jurisdiction. It has been constituted on 28th January 1950. With this, we'll go to High Courts. So while we are talking about entire India, we say that Supreme Court is the highest court, apex court, and it is having power in respect of all the original and original suits and cases and also the appellate cases that are decided within the territory of India, or sometimes in cases relating to the disputes that has arisen in other countries but connected to our country. That is for the entire India. Then what about the state? In state, almost in all states, we are having high courts. The high courts are the highest judicial body at the state level. Article 214 lays down the authority of high courts. there are now about 26 or 28 high courts in India, which you can refer your textbook for this, because recently Telangana High Court is established and we have got common high court for Punjab and Haryana, and separate high court for Jammu and Kashmir state. That state is divided into one union territory and two states, it seems. So you have to refer and find out about how many courts are there in India. Generally, maybe 27 or so high courts in India. Then again, what is the jurisdiction of the high court? What are the powers of the high courts? High courts exercise civil or criminal jurisdiction only if the subordinate courts in the state are not competent to try the matters. So high courts are also having original jurisdiction and appellate jurisdiction, but connected to the subjects or matters relating to the state for which that high court is established or formed. So high courts may even take up appeals from lower courts. Again, the high court judges are appointed by the President of India upon the consultation with the Chief Justice of India and the Chief Justice of High Court and the Governor of the state. So you have to refer the Article 214 about understanding the authority of the high courts and also how the judges are appointed for high court and all that, the Constitution of India. Then district courts. So high court is meant for the entire a particular high court. Generally for each high court, for each state, one high court is there, but in some places a common high court is also there, which I referred earlier at Punjab and Haryana. Then at the district level, district is the unit within the state. There are several districts in a state, and for each district, some system is adopted or established within the permissible limits of the Constitution. And district courts are established by the state governments of India for every district or group of districts based on the caseload and population density. Like now in Telangana, after that state is formed, several district courts are established, considering about the need because of the caseload being more and all that. And district courts are under the direct administration of high courts, are owned by the high court judgments. Again, in district courts, there are two types of courts, civil courts and criminal courts. District courts are presided over by the district judges, additional district judges, and in some cases, basing on the caseload, additional or assistant district judges also may be appointed. What do you mean by assistant district judges? We will talk about it at a later level. So let us understand at the district level, there are civil and criminal courts, and district courts are presided over by the district judges. And in one district or some 2 or 3 districts also, because of the caseload and their population density, separate courts at district level may be established of the cadre of district judge, and appeals against the district court judgments lie directly to the high court. So high courts are district courts are subordinate to high courts directly, both for administration and also for implementation of the judgments of the Supreme Court and High Court. This is at the district level and district court, sometimes 2 districts or 3 districts also. Then after district level, we have got subordinate courts at in a district of a state, there are lok adalats and village courts, and all these are subordinate courts at the village levels, which provide a system for alternative disputes resolution in villages. Let us not talk about village courts and lok adalats today. We will discuss about them later. But after district courts, below to the district courts, there are subordinate courts which are within the control of the High Court of a state, but general administration is being controlled for day-to-day affairs by the district courts. So what are those courts? We call them as subordinate courts. At first level, sub-judges. Again, the sub-judges in sub-courts, we call it as sub-courts. At sub-courts also, two types of courts. For civil side, we call them as sub-court. Criminal side, we call them as assistant session judge. So district court is called as sessions court, and sub-court is called as assistant sessions court. That is below to the district court. Civil side sub-courts, they function as sub-courts presided by a sub-judge. Same person with competence, with same powers. When he is working in criminal side, he is called as assistant session judge. So sub-courts, two types of courts. For civil side cases, decisions, subordinate courts law, we call them as sub-courts. For criminal side, we call them as assistant session judges. Then below to that, we have district municipal courts at taluk level, in fact. In district municipal courts also two categories. One is civil side, we call as district municipal, or district magistrate, district municipal. We call him as district municipal, or we call them now as junior civil judge. In case of subordinate courts, we call them as senior civil judge. In case of district court, we call them as district judges. I am referring about the names of the cadre of the judges. At High Court, we call the judges as High Court judges. At Supreme Court, we call them as Supreme Court judges. So at lower level, that is at municipal level or taluk level, the judges are called, for civil side, junior civil judges or district municipals. In criminal side, we call them as magistrates or judicial first class magistrate or JFCM, like that. The powers and also the jurisdiction of each court is clearly defined under particular law. Again, in a criminal side, there are two types of judges at taluk level: judicial magistrate first class, judicial magistrate second class. Their powers are different. And they deal with only criminal cases, but depending upon the punishment for an offense, and also depending upon the area over which the particular criminal side magistrates are having powers, they will be called as judicial magistrate of first class, judicial magistrate of second class. Second class magistrate is subordinate to
first class. Face సరిగా కనిపించటం లేదు సార్. ఇప్పుడు బాగా కనపడుతుంది. రైట్, థ్యాంక్ యూ.
Judicial magistrate in criminal side, sometimes same judge may be presiding both courts, civil and criminal courts, while he is functioning as a district municipal or junior civil judge. He will be referred as a judge deciding the civil cases, and his designation is called as district municip or junior civil judge. While the same person is functioning in criminal side, depending upon the powers and jurisdiction of him, he will be referred as magistrate first class or magistrate second class. Regarding Lok Adalat and village courts, in some areas village courts are established. So far as Lok Adalat system is concerned, these are subordinate courts at the village level, which provide a system for alternative dispute resolution in villages. Totally, they are different. In Lok Adalats, what they do is, they call the parties and discuss with them and convince them and make them to have a amicable solution, and then they give an award, not judgment. So Lok Adalat system, village courts are quite different to the regular courts system, rather Indian judicial legal system. In case of Indian legal judicial system, what the judges are expected or the courts are expected is to follow a procedure of conducting trial of a case and then take evidence and then hear the arguments and finally give a judgment. In case of Lok Adalats and village courts, no evidence is recorded. It is making the people to understand what is exactly the law, and in order to avoid the unnecessary disputes and to save the time, to have amicable settlement. This is what Lok Adalats and village courts, they do. Then we are having tribunals. In the constitution itself, there is a provision for the government with a power to set up special tribunals for the administration of specific matters such as tax cases, land cases, consumer cases, etc. So, while we are discussing about Indian legal judicial system, we have to understand about the tribunals also. All these tribunals, originally they work under the purview and control of the high courts. Generally, in respect of specific matters, these tribunals are constituted with specific powers. The matters such as tax cases, land cases, consumer cases, etc. are being decided by tribunals. Sometimes a law is also made to create tribunals and decide the matters. Maybe this is all made to have speedy disposal of the cases, or a particular subject is required to be disposed of by a person competent to decide such matters, do not have competency as a trained qualified judges. Trained qualified judges, they are appointed based on the result of exams conducted and interviews followed by the exams, and they are trained and they are having law degrees and all that. In case of tribunals, a person having knowledge of particular law relating to the subjects such as tax cases, tax, land, consumer, and the cases related to such subjects. If that man is having proficiency, he is also considered appointed as a member of the tribunal. Likewise, competency, rather method of selection of the judges for tribunals is different to the courts. So let us now understand what do you mean by appellate court jurisdiction. Appellate jurisdiction refers to the authority of a court to review a case decided by a lower court. The first court where the case is decided after conducting trial and recording of evidence and hearing the arguments is called a court court having original jurisdiction. Original jurisdiction means that the court which recorded the evidence while conducting trial and actually seen the witnesses and refer the original documents, and then after giving the opportunity as provided under law regarding hearing of the case, giving if a decision is given by that court, that is called original court or original jurisdiction is being exercised. But whereas appellate jurisdiction is concerned, it refers to the authority of a court. What it does, it hears, it rehears or review a case already decided by a competent lower court. That is appellate jurisdiction. So I already told you that in India, appellate jurisdiction is vested, generally speaking, in both the Supreme Court and High Courts. In some cases, even to district court or subordinate court, that is Sessions Court, Assistant Sessions Court. So all courts are having original jurisdictions in respect to certain subjects or certain areas. Both appellate jurisdiction also, except the first courts, that is district municipal courts in civil side and in criminal side, judicial first class magistrate courts. They don't have appellate powers or appellate jurisdiction. So above the first courts, there are courts such as Senior Civil Judges Court or Assistant Session Judge Court at lower level, taluk level or sub-region level with appellate and original jurisdiction powers. And then above to those courts, district courts are there. And above the district courts, as I referred earlier, are having original and appellate jurisdictions. And above district courts, high courts are there. Above high courts, Supreme Court is there. So let us now understand what do you mean by civil case and what is mean by civil courts. We were referring right from the beginning that there are different cases and courts which are called as civil courts, civil case on one side, criminal courts and criminal case on the other side. What civil courts do is, civil courts provide remedies for the civil wrongs committed by individuals against other individuals and entities or governments. So if a civil wrong is committed by any person, the aggrieved party can approach the civil court for getting a remedy for the wrong committed against him. That wrong may be committed by individual or any entity or part of government or any system. Likewise, any person whose civil rights are affected, that any person includes the government authorities also, then they can approach the civil courts to provide remedies for the civil wrongs committed by the any other individuals or entities. Generally, civil matters range from property disputes to breaches of contract to diverse cases. Civil courts follow the principle of Roman principle, ubi just, ubi remedium. What is the meaning of it? For every wrong, the law provides remedy. Law contemplates that if any person commits a wrong, if it is civil wrong, then there must be a remedy for it. So that's why, in order to understand what is civil case, we must understand section 9 of the Civil Procedure Code.
Excuse me, sir. Shall we join again? This meeting will end, sir.
Okay, madam.
Yeah.
Again, I will join.
Yes. Thank you.